When someone passes away, their family is dealing with grief, with funeral arrangements, with phone calls to relatives, with 100 things at once. And in the middle of all of that, there is also a financial side that has to be handled. Social Security, Medicare, bank accounts, survivor benefits, and it has to be handled correctly, often within a fairly narrow window of time. This video is not designed to alarm you. It's designed to be the calm, complete guide that most families don't have when they need it. Because in the moment this actually happens, nobody has the time or the emotional bandwidth to research 11 different processes across Social Security, Medicare, banks, and the IRS. I'm going to walk through all 11 steps, in the order they typically need to happen, calmly and clearly, so that if you're watching this in advance, you're prepared. And if you're watching this because it's happening right now, you have exactly what you need. My name is Lucian Vane, and I've spent years studying how Social Security, Medicare, and the broader financial system respond when someone passes away. Specifically because this is one of the moments when families are least equipped to research anything, and most likely to make a costly mistake simply from not knowing the process. I want to say something directly before we begin. If you are watching this because someone you love has recently passed away, I am sorry for your loss. Please take this at whatever pace feels manageable. None of these 11 steps need to happen in a single sitting, and I'll be clear throughout about which ones are truly time-sensitive and which ones have more flexibility. Let's begin. The very first practical step, and the foundation for almost everything that follows, is obtaining certified copies of the death certificate. Here's why this matters so much, and why I want to start here. Nearly every institution you'll need to contact, Social Security, banks, pension administrators, life insurance companies, the county recorder's office, will require an official, certified copy of the death certificate before they will discuss the account or process any claim. A photocopy or a scanned image is generally not accepted. They need the certified original with a raised seal or equivalent official marking. The funeral home handling the arrangements typically assists with ordering these directly through the county or state vital records office, and this is usually the fastest and most convenient way to get them. If the funeral home doesn't offer this, you can order certified copies directly from the vital records office in the state where the death occurred. Here is the question that trips up almost every family. How many copies do you actually need? The honest answer is more than you'd think. A reasonable starting point is 10 to 15 certified copies because nearly every institution keeps the original you send them rather than returning it. Each certified copy typically costs somewhere between $10 and $25 depending on the state, so ordering in bulk up front is both more convenient and often slightly less expensive per copy than ordering a few at a time and running short later. Action step. When working with the funeral home, ask specifically for at least 10 to 15 certified copies of the death certificate as part of the arrangements. If you need additional copies later, you can always order more directly from the state vital records office, though it may take longer than getting them through the funeral home initially. The second step is reporting the death to the Social Security Administration, and this is genuinely one of the most time-sensitive steps on this entire list, so I want to walk through it carefully. In most cases, the funeral home will report the death to Social Security on the family's behalf as part of their standard process. They typically ask for the deceased person's Social Security number specifically for this purpose. This is usually the fastest and most reliable way for the report to happen, because funeral homes have an established electronic reporting system with the SSA. However, and this is important, you should not simply assume this happened. Confirm directly with the funeral home whether they reported the death to Social Security, and if there's any uncertainty, the family should also report it directly. If you need to report it directly, you can call the Social Security Administration at 1-800-772-1213, available Monday through Friday. You cannot report a death to Social Security online. This specifically requires a phone call or an in-person visit to a local Social Security office. Here's why the timing matters so much, and this connects directly to the next step we'll cover. Social Security benefits are paid for the month they're due, but a person must be alive for the entire month to be eligible for that month's payment. If a payment was already issued for a month, the person did not survive completely. that payment generally has to be returned. The sooner the death is reported, the sooner this gets resolved cleanly, rather than creating a more complicated repayment situation later. Action step: confirm with the funeral home whether they reported the death to Social Security. If they did not, or if you're unsure, call 1-800-772-1213 as soon as possible to report it directly. Have the deceased person's Social Security number and date of death ready when you call. This is the step that catches more families off guard than almost any other on this list, so I want to explain it clearly and without alarm, because it is a completely normal part of the process, not a penalty or a mistake on the family's part. Here is the rule, stated as clearly as possible. Social Security payments are issued the month after they are earned. For example, the payment received in May is actually for the benefit owed for April. A person must have been alive for the entire month to be entitled to that month's payment. This means that if someone passes away during a given month, the payment they would normally receive the following month for that final partial month is generally not owed to them, and if it was already deposited, it typically needs to be returned to Social Security. Let me give you a concrete example to make this fully clear. If someone passes away on June 10th, they were not alive for the entire month of June. The payment that would normally arrive in July, which is payment for the month of June, is generally not owed to them, because they didn't live through the complete month of June. If that payment is deposited anyway before Social Security is notified, the bank or the family will need to return it. This is exactly why prompt reporting in Step 2 matters so much. The sooner Social Security is notified, the sooner they can stop any payment that wasn't earned from being issued in the first place, which avoids the more complicated process of having to return a payment that already landed in the account. If a payment was already deposited and needs to be returned, do not withdraw or spend those funds. Contact the bank and explain that a Social Security payment needs to be returned due to a death, and the bank can typically work directly with Social Security to handle the return. If the funds have already been spent inadvertently, contact Social Security directly to discuss repayment arrangements. This is a manageable, routine conversation, not a legal crisis. The fourth step is one of the most financially significant on this entire list, and it is also one of the most commonly misunderstood: applying for survivor benefits. Here is the single most important thing to understand. Even though Social Security is notified of the death in Step 2, that notification alone does not start survivor benefits for a surviving spouse, child, or other eligible family member. A separate application has to be filed. Let's go through who is generally eligible. A surviving spouse who is 60 or older can apply for survivor benefits, or 50 or older if they are disabled. A surviving spouse of any age who is caring for the deceased's child who is under 16 or disabled can also apply. Unmarried children of the deceased who are under 18 or up to 19 if still in high school may be eligible. And in some cases, dependent parents of the deceased may also qualify. Here's how the benefit amount works. A surviving spouse who has reached their own full retirement age is generally eligible to receive 100% of the deceased spouse's benefit amount, meaning the higher of the two spouses' benefits becomes the amount the survivor receives going forward, replacing their own smaller benefit if applicable. If the surviving spouse claims survivor benefits before reaching their own full retirement age, the benefit is reduced, similar to how claiming regular retirement benefits early results in a reduction. This is worth discussing carefully with a Social Security representative because the right timing decision depends on the survivor's age, health, and financial circumstances. One detail that matters and that many families don't realize: a surviving spouse can actually choose to claim survivor benefits first and then switch to their own retirement benefit later if it would be higher, or claim their own benefit first and switch to the survivor benefit later. This sequencing decision can meaningfully affect total lifetime benefits, and it's worth asking the Social Security representative specifically about both options when you apply. Action step: contact Social Security at 1-800-772-1213 or visit a local office to specifically apply for survivor benefits. This is a distinct, separate application from simply reporting the death. Ask the representative to walk through both the survivor benefit amount and your own benefit amount, and discuss the sequencing options available to you. The fifth step is small in dollar amount but worth knowing about because almost nobody claims it simply because they don't know it exists: the one-time lump sum death benefit. Social Security provides a one-time payment of $255 to an eligible surviving spouse, or, in certain circumstances, an eligible child of the deceased. This amount has not changed in decades and is genuinely modest, but it is money the family is entitled to, and claiming it costs nothing but a phone call. Here's an important detail. This benefit is not paid automatically alongside survivor benefits. It generally needs to be specifically requested, and in most cases, it's most efficiently claimed at the same time you apply for survivor benefits in Step 4, rather than as a completely separate process. Action step. When you contact Social Security to apply for survivor benefits in Step 4, specifically mention and request the one-time $255 death benefit in the same conversation or application, so you're not making a separate trip or call later for a relatively small amount. The sixth step addresses something that affects the surviving spouse directly if they were covered under the deceased person's health plan in any way: Medicare and supplemental insurance. Here's the first key point. Medicare coverage for the deceased person ends upon their death, and Social Security will generally handle closing out that Medicare enrollment as part of processing the death report. There's typically nothing additional the family needs to do specifically to close the deceased's own Medicare coverage. But here's where it matters significantly for the surviving spouse. If the surviving spouse was covered under the deceased person's employer-sponsored retiree health insurance or supplemental Medicare plan, rather than having their own independent coverage, that coverage may end or change upon the death, sometimes with very little advance notice. Action step. If the surviving spouse was covered under any employer-retiree plan, supplemental Medicare plan, often called Medigap, or Medicare Advantage plan tied to the deceased's enrollment, contact that insurance provider directly and immediately to ask, "What happens to my coverage now, and do I have a special enrollment period to make changes?" Here's an important protection to know about. The death of a spouse generally triggers a special enrollment period, allowing the surviving spouse to make changes to their own Medicare coverage, including switching plans, outside of the normal annual enrollment window, specifically because this is considered a qualifying life event. The seventh step is one of the most practically important on this entire list, because handling it incorrectly can leave a surviving spouse temporarily locked out of money they need for everyday expenses. Here's the situation that catches families off guard. If a bank account was held solely in the name of the deceased person, even if the surviving spouse used that account regularly for household expenses, the bank will typically freeze that account once they're notified of the death because, legally, it now needs to go through the proper transfer or estate process before funds can be released. This is precisely why the type of account ownership matters so much, and why it's worth understanding now, even if you're watching this for future planning purposes. A joint account with rights of survivorship generally passes automatically and remains accessible to the surviving account holder without going through this freezing process. A payable on death, or POD, designation on an account also allows for a relatively smooth transfer directly to the named beneficiary. If you're in the position of planning ahead for your own future or helping aging parents organize their finances, this is genuinely one of the most important and most overlooked pieces of basic estate preparation. Making sure essential household accounts are jointly held or have a clear payable on death designation, specifically to avoid this freeze when one spouse passes away. If you're dealing with a frozen sole name account right now, here's what to do. Contact the bank directly, explain the situation, and ask what is needed to either release funds for immediate essential expenses. Many banks have a process for this, or to begin the estate transfer process. Having those certified death certificates from Step 1 ready will speed this along considerably. One more important note. Avoid using the deceased person's individual debit or credit cards after their death, even for small or routine purchases, as this can complicate the estate process and, in some cases, raise legal concerns. Use accounts that are properly in the surviving spouse's name, or that have transferred appropriately instead. The eighth step addresses pensions and retirement accounts, which often have their own separate rules, separate from Social Security, and separate deadlines that families need to be aware of. If the deceased was receiving a pension from a former employer, the pension administrator needs to be notified of the death directly. This does not happen automatically through Social Security, and pension plans vary enormously in how they handle continuation of benefits for a surviving spouse. Some pensions include a survivor benefit option that was elected when the deceased originally began receiving payments, meaning the surviving spouse may continue to receive some or all of that pension going forward. Other pensions stop entirely upon the recipient's death, depending on the choices made at the time of retirement. Action step: contact the Human Resources or Benefits Department of the former employer or the pension plan administrator directly and ask, was a survivor benefit option elected on this pension? And if so, what is the process for the surviving spouse to begin receiving it? For IRAs, 401ks, and other retirement accounts, the process is generally more straightforward if a beneficiary was properly named on the account. These typically transfer directly to the named beneficiary without going through probate. Contact the financial institution holding the account directly, provide the certified death certificate, and ask about the specific transfer process, since rules differ depending on whether the beneficiary is a spouse or another individual. The ninth step addresses a topic that creates a lot of unnecessary anxiety for families, often because of a common misunderstanding: what happens to debt after someone passes away? Here is the principle that matters most. In general, family members are not personally responsible for paying off the debts of a deceased relative simply because they are family. Debt is generally paid from the deceased person's estate, meaning their individually owned assets, not from the personal assets of surviving family members, with some specific exceptions. The exceptions to be aware of: if a debt was jointly held, a joint credit card, a joint loan, a jointly signed mortgage, the surviving cosigner or joint account holder generally remains responsible for that debt. In community property states, a surviving spouse may have additional responsibility for certain debts incurred during the marriage, even if the debt was technically only in the deceased spouse's name. Action step: do not feel pressured to immediately pay off debt collectors who contact you claiming you're responsible for a deceased relative's individual debt. Verify the nature of the debt first. If a debt collector is being aggressive or making claims that don't sound accurate, it's reasonable to ask for everything in writing and to consult with an attorney before paying anything, particularly for larger amounts. The 10th step is one that's easy to forget in the midst of everything else, but it remains a genuine legal obligation: filing the deceased person's final tax return. A final federal tax return generally needs to be filed for the deceased person, covering the period from the beginning of that tax year through the date of death. This is typically the responsibility of the surviving spouse or the executor of the estate, and it follows the normal tax filing deadline for that year. If the surviving spouse is filing the return, they can generally still file jointly for that final tax year, which often provides a more favorable tax outcome than filing as an individual. The return is marked to indicate the taxpayer is deceased and the surviving spouse signs as the surviving spouse. If the deceased had income from investments, a pension, or other sources beyond Social Security that continued generating income after death, for example, interest accruing on an account before it's transferred, that income may need to be reported on a separate estate tax return, which is a more specialized situation worth discussing directly with a tax professional or accountant. Action step: gather all tax documents for the deceased, W-2s, 1099 Social Security statements, for the year of death, and either work with the tax preparer who normally handled the couple's or individual's taxes or consult a new tax professional specifically experienced with final returns to ensure this is filed correctly and on time. The 11th and final major step is more of a category than a single action: systematically working through the remaining accounts, memberships, and benefits that were tied to the deceased person to either close them, transfer them, or update them appropriately. This includes life insurance policies. Contact the insurer directly with the certified death certificate to begin the claims process. which is generally one of the more straightforward processes on this list, since it's specifically designed to be activated upon death. This includes annuities, which may have different payout rules depending on how they were structured. Some continue paying a surviving spouse, others were structured to end at death, so contact the annuity company directly to understand the specific terms. This includes the Department of Motor Vehicles to transfer or cancel vehicle registration and update or surrender the deceased's driver's license. This includes utility companies and any household accounts that may need to be transferred into the surviving spouse's name, if they weren't already jointly held. This includes credit monitoring. It's worth placing a notice with the major credit bureaus indicating the person is deceased, which helps prevent identity theft using the deceased person's information, something that unfortunately does happen and that families don't always think to protect against. And finally, this includes simply notifying close friends, extended family, and any organizations the deceased was actively involved with, so that mail, calls, and renewal notices stop arriving unexpectedly over the following months, which can otherwise create small but repeated emotional difficulties for the surviving family. Before we close, I want to walk through the mistakes that come up most often because recognizing these patterns in advance is often the difference between a smooth process and a stressful one. Mistake 1. Assuming survivor benefits start automatically. As we covered in Step 4, this requires a specific separate application. Many families wait weeks or months before realizing this application was never filed. Mistake 2. Spending or withdrawing from a frozen or soon-to-be frozen sole name account before understanding the proper transfer process, which can complicate the estate process significantly. Mistake 3. Not confirming whether the surviving spouse's health insurance coverage was tied to the deceased's plan until a coverage gap has already occurred. Mistake 4. Paying debt collectors immediately without verifying whether a debt was actually jointly held or solely the deceased's individual responsibility. Mistake 5. Forgetting that a separate pension notification is required. Social Security being notified does not automatically notify a former employer's pension administrator. Mistake 6. Not requesting enough certified death certificates up front, which causes delays throughout this entire process as additional copies have to be ordered and waited for partway through. Every one of these mistakes is completely understandable. They happen because families are managing grief and a dozen unfamiliar processes simultaneously. The goal of walking through them here isn't to create pressure. It's to make sure that if you're going through this, you have a clear map rather than having to learn each lesson the hard way, in real time. Here is your complete 30-day checklist, all 11 steps in order. 1. Order 10 to 15 certified copies of the death certificate, ideally through the funeral home. 2. Confirm the death was reported to Social Security, or report it directly at 1-800-772-1213. 3. Understand that the final payment may need to be returned, and don't spend it if Social Security indicates it wasn't owed. 4. Apply separately and specifically for survivor benefits. This is not automatic. 5. Request the one-time $255 death benefit at the same time you apply for survivor benefits. 6. Check whether the surviving spouse's health coverage was tied to the deceased's plan, and use the special enrollment period if needed. 7. Confirm bank account access, understanding the difference between joint accounts, payable on death accounts, and sole name accounts that may be frozen. 8. Contact pension and retirement plan administrators directly, since this is separate from Social Security. 9. Verify whether any debt is jointly held before paying anything to a collector. 10. File the final tax return by the normal filing deadline. 11. Work through the remaining accounts: life insurance, annuities, the DMV, utilities, subscriptions, and a credit bureau notification to protect against identity theft. I know this is a lot of information, and I know that if you're going through this right now, it can feel overwhelming on top of everything else you're carrying. You do not have to do all 11 steps in a single day, or even in a single week. Take them in order. Lean on the funeral home and the Social Security Administration for guidance along the way. And know that every family that has gone through this has found their way through it. And you will too. If this video helped you, or if you think it could help someone you know prepare in advance, please consider sharing it. This isn't content designed to go viral for its own sake. It's the kind of practical guide that genuinely makes a difficult time a little bit easier, and that's worth passing along. If you'd like more videos like this, covering the financial and legal realities that families face but rarely have a clear guide for, subscribe and I'll see you in the next one.